In this video of our multi-video seller series, we shall look at the role and duties of the closing company as the real estate transaction moves from contract to close. Our last few videos have explained what happens on the buyer's side during the transaction in the way of delivering the escrow deposit, the different types of financing, the inspection, the appraisal, the survey, and arranging the homeowner's insurance. What in the meantime is happening on the seller side of the transaction? Here are 11 duties that the title company or attorney office, both also generally known as the closing company, handle whilst preparing the transaction for a timely and smooth closing. We have already touched on some of these items in an earlier video in this series when we looked at the costs of selling.
Number 1. Title commitment. One of the first things that the closing company will attend to is issuing the title commitment. This process usually takes about 2 weeks. A title commitment is the closing company's promise to issue a title insurance policy for the property after closing. The commitment contains the same terms, conditions, and exclusions which will be written in the insurance policy. A title commitment is the document that will guarantee the buyer title rights to the property after closing.
Number 2. Title search. A title search is normally ordered by the closing company from a specific title search company, as searching the title can be a long drawn-out process. Typically, the title search will confirm that the seller is truly the rightful owner with a right to sell the property to the buyer. The title search will also establish whether there are any other financial or legal claims on the property. A few examples include any outstanding property taxes, any liens against the property, and any easements of any kind. If there are any outstanding claims on the property, the closing company will work with the seller and the listing agent to have those rectified prior to closing.
Number 3. Municipal lien search. It might seem that a municipal lien search would be part of the normal title search, yet that is not the case. Not only do title underwriters not perform a municipal lien search, but they specifically exclude these matters from title coverage. That is why it is important to allow time for a closing company to order this type of search, which may take some time to be completed since the search is multifaceted. The search will unearth unrecorded liens such as unpaid county taxes, code violations, special assessments, unpaid utility bills, and open or expired permits. Similar to issues occurring in the title search, issues occurring in the municipal lien search will be addressed by the closing company, who will work with the seller and the listing agent to have these issues resolved prior to closing. Failure to catch these issues prior to closing would result in the buyer then being responsible for resolving these issues post-closing as and when they happen to make their presence known. This could prove both time-consuming and costly for the buyer.
Number 4. HOA Estoppel Letter. Another item ordered by the closing company at the very start of the closing process is the Estoppel Letter, as this must be ordered prior to closing on any home which is in a community with an HOA or homeowners association. The HOA is obligated by statute to provide an Estoppel letter within 10 business days of receiving a written request from the closing company. An Estoppel letter, which is hand-delivered or delivered electronically, is valid for 30 days from the date of issue. If sent by regular mail, it is valid for 35 days. If the seller is prepared to pay a rush fee, the HOA Estoppel letter may sometimes be obtained much more quickly, and this would need to be the case if the buyer is a cash buyer and the closing period is very short. An Estoppel letter is used to facilitate the closing by providing details of any fees or assessments that a seller may owe to the HOA. In Florida, buyers are liable post-closing for any unpaid dues or assessments owed by the seller. The letter also itemizes any transfer fees or capital contributions which the closing company will need to collect from the buyer at closing. Sometimes communities have 2 HOAs. One, for example, could be taking care of the community landscaping and the exterior of the home, and the second one is taking care of the clubhouse and other community amenities. In the case of 2 HOAs, then 2 estoppel letters need to be ordered and 2 fees paid.
Number 5. Lender payoff. In cases where the seller has a mortgage on the home which the seller is selling, the closing company will order a payoff from the seller's lender. This will necessitate the closing company first obtaining written permission to do so from the seller. The payoff obtained by the closing company will be based on the closing date, so should the closing date be delayed, an updated payoff will have to be obtained.
Number 6. Liaising with the buyer and seller. Throughout the transaction, the closing company will be in frequent communication with both the buyer and seller, obtaining any necessary information that the closing company may require along the way. Buyers and sellers must be ready and willing to share relevant information with the closing company when asked, and to share that in a timely manner to avoid causing a delay in the closing date.
Number 7. Liaising with the buyer's agent and seller's agent. The closing company keeping in good communication with the 2 agents is key to having a smooth and timely closing. Any amendments to the contract during the closing process will be supplied to the closing company by the agents. Additionally, any issues that may crop up with the title search, municipal lien search, HOA Estoppel Letter or survey may require the involvement of one or other of the agents to help the closing company resolve the problem.
Number 8. Liaising with the buyer's lender. From the time of contract up until the closing day, the closing company will be in frequent communication with the buyer's lender, making sure that the lender has received the necessary title work when the buyer and seller first go under contract, and then working with the lender to prepare the final settlement statement, which is currently called an ALTA.
Number 9. Liaising with the FIRPTA Accountant. In the case of a foreign national seller, the closing company will also be in communication with the seller's accountant to make sure that the necessary FIRPTA, Foreign Investment in Real Property Tax Act, regulations are being met at closing. This will necessitate the closing company supplying the accountant with a preliminary settlement statement in advance of the closing. This enables the accountant to have an idea of the approximate seller costs associated with the sale and can use these costs to offset any capital gain that the seller may have made through disposing of his or her foreign asset. We shall cover the topic of FIRPTA in greater detail in a later video in this series.
Number 10. Closing documents. Closer to the closing date, the closing company will prepare the documents required to be signed by the buyer and seller. In cases where the buyer is obtaining a loan, the closing company will need to wait to receive the lender package from the lender before the closing documents can be prepared, and this lender package usually only arrives with the closing company a day or 2 prior to closing, and sometimes even on the day of closing. For cash buyers, the closing documents may be drafted and signed several days prior to closing, making this type of closing a much smoother and less last-minute affair. It is possible for a seller to sign his or her documents in advance of the closing date, and that is particularly beneficial to homeowners who have actually been living in the home, as they do not need to deal with signing closing documents and moving belongings on the same day, which can be very stressful. We shall cover the signing of documents in a later video in this series.
Number 11. Handling of funds. In addition to all of the duties we have just mentioned, in most cases, the closing company is also the company who is responsible for holding the escrow deposit collected once the buyer and seller are under contract. The closing company will keep the escrow until it is either released to either the buyer or seller in cases where the sale falls through, or released at closing to form part of the buyer's funds to close. The closing company is also responsible for collecting the remainder of the buyer's funds to close and the money from the buyer's lender if the buyer is obtaining a loan. The closing company will then disperse the funds to the seller and other pertinent parties post-closing, and we shall cover this in detail in a later video in this series.
Thanks for watching, and be sure to check out the rest of the videos in this seller series.